counsel to get situated. All right, counsel, your request.
Your Honor, as the court knows, the family has asked that all exhibits admitted into evidence be shown here in open court. We are grateful to the court for allowing the family to view many or most of the exhibits today that were admitted. They were viewed here openly in court. And obviously that was done after the court struck what we think is the appropriate balance after a very thoughtful and thorough analysis. I'm going to ask the court to reconsider one of its prior rulings. I understand reconsideration is always a big ask, but I do think, Your Honor, that if the court were to display publicly, or just in the courtroom, Exhibit 12.1, which is the enhanced video, version 12.4, which was played in court, was very hard for the family to view. We think that we asked the court that since the court's considering it, the family should be able to view it as well. When conducting the appropriate balancing, the court, as the court knows, can alleviate any concerns about proper jury selection with certain tools at its disposal. However, if the court were to deny the family the right to view that video, there's no cure. It's either they get to view it or they don't. So we would ask the court to reconsider its prior ruling and to display just in the courtroom Exhibit 12.1, which is the enhanced video. Thank you, Your Honor.
Thank you. Turning to the parties, starting with the state, Mr. Grunander.
Thank you, Judge. The state does not oppose publishing 12.4 in the courtroom. I think we've tried to make it very clear throughout this case that we favor openness and transparency as much as appropriate. I'll submit it on that.
Thank you, Mr. Grunander. To defense, Mr. Burt.
My apologies, that's 12.1, not 12.4.
Thank you.
Judge, at this point in the proceeding, we're asking the court to keep focus on the purpose of this hearing. And as the justice has said in the Estes case, the purpose of a trial, and I know this isn't a trial, but the same logic applies, is to determine the defendant's guilt. It's not to educate the public or the victim's family or the world on what evidence the government or the state has. As the court knows, we have witness availability problems. We spent the bulk of today and yesterday arguing about nothing to do with the evidence in the case, but with rights of third parties. And it's appropriate for the court to consider that, but at some point, I think the court has to return to the purpose of these hearings, which is to expeditiously hear the evidence and then determine probable cause. And I want to point out to the court, Ms. Kirk has been very adept at holding press conferences at which she has revealed evidence. She has represented that the state is her attorney. She has access to all the evidence that the state has publicized and that the media and her own lawyer argues is already in the public domain. So they're perfectly free to go outside this courtroom under the court's protective order. They're free to go out and hold press conferences and announce to the world outside the courtroom what they think the evidence is. They have the availability of that evidence. But the court's role, I think, at some point is to exercise some control, move the case forward, and especially when we have witness availability problems. And I'd ask the court, whatever the court does, if you're going to allow revisiting or replaying of evidence for the sole purpose of informing the world or Ms. Kirk or anybody else, that the court do it at the end of the process and not at this point where we will be deprived of our ability to call this witness, because she has to be done today.
Thank you, Mr. Burt.
Thank you.
Briefly, and I say that because time is of the essence, not because I don't want to hear what you have to say.
I understand, but there was a lot that was just said that's just not true.
Well, so let me put this in a spot where we need to be. And I understand that there's opinions, but I have to keep this to the probable cause. I don't want this to go to a back and forth about issues that lie outside of probable cause. And I realize statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you. The family has not seen this video. It hasn't. It doesn't have access to the evidence the state has. The state is the state, and Mrs. Kirk and the family have their representatives. There's a completely distortion of reality that was just put forth. And this isn't about educating anybody about anything. This is about allowing the family to see the evidence that's been gathered after a 10-month investigation in which a father, a husband was assassinated. That's what this is about. So we ask you to please allow the family to view the video like the court has viewed in order to allow the family to process this moment.
Thank you.
Thank you.
Anything further before the court issues its ruling and we go from there?
Not from the state.
All right. Defense? No. All right. All right. So I recognize that the Utah Constitution under Article 1, Section 28 recognizes victims' rights, and the court respects those rights, and as has been previously stated, balances those rights with the constitutional rights of all parties. I will reserve my ruling on that and maybe revisit it tomorrow. But because we have an issue of expiring time and one witness that needs to leave today, I need to turn to that. I'm not ruling that that cannot happen, but for today, we need to focus on this to getting this defense witness on the stand and off the stand. And so please, if I do not remember, the parties can remind me and we can revisit this tomorrow. So again, I'm not saying yes, I'm not saying no, I'm simply saying we need to get to this witness, and I'm happy to readdress this tomorrow. Okay? All right. Mr. Burt. All right, Samantha Carer is being requested. If you can go ahead and retrieve her,
Yes.
bring her into the courtroom.
Someone's doing that.
Is somebody grabbing her?
Yes.
Okay, thank you, Mr. Burt. I just couldn't tell and wanted to make sure. All right, Ms. Carter, if you wouldn't mind coming forward, right by our bailiff to be sworn in.
Please raise your hand. Do you solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. You can sit.
All right, thank you, ma'am. If you wouldn't mind coming forward, having a seat at the witness stand. To your left is a water bottle if you choose. It looks like you brought your own as well. And after you're situated, if you wouldn't mind pulling that microphone toward you, just to ensure that your testimony is picked up on the record. Mr. Burt, your witness.
Thank you. Good afternoon. Could you tell us your name, please?
Yes, my name is Samantha Carer.
And Ms. Carter, what do you do for a living?
I am a firearm and toolmark examiner.
And where are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there? What area of expertise do you have?
I am assigned to the firearm and toolmark unit, so I receive items of evidence related to firearms, tools, toolmarks, and fired ammunition components.
At the request of the state of Utah, did you conduct certain examinations relevant to this case?
I did, yes.
Could you bring up State 32 in evidence?
Do you want it, Mr. Burt?
Yes, I think.
On all screens?
All screens, it's admitted and
Okay.
I think approved
All
for
right, let's go ahead and put
publication.
it on all screens because this was admitted and published previously. All right.
Do you recognize plaintiff's exhibit number 32?
I do, yes.
Are you the author of this report?
I am, yes.
Okay. What were you asked to do in relation to the examination that's documented in this report?
For the Submission 1 report, I received a firearm, cartridge case, 3 cartridges, 1 bullet jacket fragment, and 4 lead fragments. I was asked to test fire the firearm and compare the test fires to the cartridge case and the bullet jacket fragment. I also was asked to do a toolmark characterization on the cartridge case and the cartridges, and then I also ran a general rifling characteristic search on the bullet jacket fragment.
Okay. And are your conclusions accurately documented in your report?
Yes.
Could you turn to page 2 of the report? Second, bottom of the page. Those 2 paragraphs, please. Did you write in your report, these conclusions conform with the relevant Department of Justice policy on uniform language for testimony?
Yes, that is always added to our reports.
And do you have a standard operating procedure that requires that in each examination you do, this language has to be in there?
We do, yes.
Okay. And I want to ask you to review the document that is referenced in that language, which would be, and this is just for her only, Exhibit 11. Let me know when you can see that. Are you able to view that?
Yes,
Is this the ATF's, is this a language referred to in your report?
it is, yes.
The written policy of the Department of Justice concerning uniform language for testimony and reports for the forensic firearm toolmark discipline pattern examination.
It is, yes.
I move that into evidence.
This is, what is the title of this exhibit?
Your Honor, this would be Carner 11.
All right, and what level of publication are you requesting, Mr. Byrd?
Both public and admittance into evidence.
To this date?
No objection.
All right, Carner 11 is admitted into evidence and may be published on screens and captured by the camera.
Thank you. And you can publish that? Ms. Carner, can you tell us what the purpose and scope of this document is?
Yes, this is the DOJ Department of Justice's uniform language for testimony and report, and it standardizes the appropriate language an examiner will use during reporting and their testimony. And DOJ published this to standardize the wording that examiners would use across their forensic laboratories.
And was this published in part because of some criticism that the prior testimony, not by you, but by other people, may have gone beyond the bounds of science?
I don't know why DOJ published it. It was before my time.
Do you know how long this has been the policy of the Department of Justice?
I do not off the top of my head, no.
Are the reports that you issued in relation to this case in conformity with this policy?
They are, yes.
Okay. Now, could you go to page 3 of that report? Where it says qualifications and limitation of firearm toolmark discipline examination. You're familiar with that part of the policy, correct?
I am, yes.
And the portion of the policy that says a conclusion provided during testimony or in a report is ultimately an examiner's decision and is not based on a statistically derived or verified measurement or comparison to all other firearms or tool marks. Therefore, an examiner shall not, and then it lists several propositions. You're familiar with that language?
I am, yes.
And it says that an examiner shall not assert that a source identification or a source exclusion conclusion is based on uniqueness of an item of evidence. Your report is not meant to imply something contrary to what's stated here, is it?
No, it's not meant to contract.
You're not asserting that a source identification is based on the uniqueness of an item of evidence.
No, I am not.
And the reason you're not doing that is because you haven't examined all possible items of evidence that could be relevant to your comparisons, correct?
I have not looked at every firearm that's been manufactured in the world, nor have I looked at every tool that's been manufactured in the world. That's correct.
Okay. The second portion of that says an examiner shall not use the term individualize or individualization when describing a source conclusion. Did you abide by that policy in this case?
I did, yes.
And you're not expressing an opinion here that the comparisons that you made are individualized to a particular weapon or a particular cartridge case, correct?
My conclusion for one of the exhibits identifies the cartridge case as being fired in the firearm, but that's all it says, yes.
Right, but you're not asserting that that's an individualized identification in the sense that's being used in this policy, are you?
No, I am not.
Okay, and then the third part of that says that an examiner shall not assert that two tool marks originated from the same source to the exclusion of all other sources. You're not expressing that opinion either, are you?
I am not, no.
It says, an examiner shall not assert that examinations conducted in the forensic firearms toolmark discipline are infallible. You're not asserting that?
I am not, no.
You're not asserting that, it says the examiner shall not assert that there is a zero error rate. You're not
Correct.
making that assertion,
No.
okay? Says an examiner shall not provide a conclusion that includes a statistic or numerical degree of probability except when based on relevant and appropriate data. You didn't conduct such an analysis here, correct?
I did not, no.
Okay. And it says, an examiner shall not cite the number of examinations conducted in the forensic firearm toolmark discipline performed in his or her career as a direct measure for the accuracy of a conclusion provided. You didn't do that, and you're not doing that here, correct?
Correct.
And then it says, an examiner shall not assert that two tool marks originated from the same source with absolute or 100% certainty, or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony, unless required to do so by a judge. You're not making any such assertions in this case, are you?
I am not.
Okay. All right, thank you. You can take that down. Now, when you conducted your analysis in this case, and in all cases, do you typically generate a case file that includes proper documentation of your examination?
I do, yes.
And did you do that in this case?
I did.
Could you display to her alone, please, Exhibit 6, Carner 6? Case file. Yes. Do you see what's displayed there?
I do, yes.
It's a 47-page. Is this your case file?
It is, yes.
Did you rely on the documents and photographs that are documented here in writing the report that the state introduced into evidence here?
How so?
Before you wrote your report, did you photograph items that you were looking at, take other notes, and then use that work product to form the opinions you reached that are documented in the report?
The notes are mostly used for initial documentation and evaluation, and then, yes, supplement to the conclusions that I make. It's all a representative image of what my conclusions are going to be. So part of it is going into the conclusion statement and then just showing proof of those conclusions.
Right, and your standard operating procedure requires that you document in your case file the basis for your opinions, correct?
Yes.
I'd move Carner 6 into evidence?
To the state.
Is this the 47-page document?
Yes.
I object. I don't see the relevance of the court's probable cause determination to review a 46-page report that includes notes.
Would you like to respond, Mr. Burke?
Yes, Your Honor, this is the basis and documentation of the conclusions reached in the expert's brief report, which expresses her ultimate conclusion, but does not contain any of the reasoning for that conclusion. So it's important for the court, I think, to understand why and how she reached the conclusions that she did.
All right, anything further?
No?
Yes, just that without testimony about what the meaning of the notes is and so forth, it is more confusing than it is probative. So under a 403 analysis, I don't think it's admissible nor helpful to the state, to the court.
All right. Mr. Bird?
I intend to focus on particular photographs which document what she received in evidence and the comparisons that she did, which are also documented in this file in the way of comparison photographs.
All right. As it relates to the objection is overruled. I find that this is relevant as it relates to State's Exhibit 30, which was admitted, as well as State's Exhibit 32, which is admitted, and the state is able to do cross-examination on this witness as it relates to this report. And so it is admitted and may be published on all levels in the courtroom and through the media.
Thank you. Ms. Carter, one of the items you were asked to look at was, as described in your report, 1 bullet jacket fragment and 4 lead fragments, correct?
Yes.
Were you informed at some point that there was a discrepancy between what you were examining and what had been documented by the medical examiner in terms of the number of bullet fragments?
I was, yes.
Were you asked to see if maybe the ATF had lost certain portions of the evidence?
No, I was not.
Right. Do you think, and was it your understanding that there were originally 7 bullet fragments, but you ended up with 4?
I was alerted that there was potentially 7 fragments from the medical examiner in a photo just a few months ago.
Okay. You're clear, though, that when you got the evidence, it was in a sealed condition, correct?
It was, yes.
And when you opened, what was it, an envelope?
A small individual manila envelope, yes.
And did you take the contents of the envelope containing the bullet and take photographs of it?
I did, yes.
Okay. Could you display page 41 of 47, that exhibit? I'm sorry, page 14. And tell us what's depicted here.
Yes, this is a picture of the as-received condition of Exhibit 6 in its entirety. That's the top picture. So you'll see Exhibit 6A all the way through 6E in descending order. And then the bottom 2 photos on the left is the Exhibit 6A bullet jacket fragment, and that is the view of the exterior. And then the photograph on the right is the Exhibit 6A bullet jacket fragment, and that's the view of the interior of it.
Okay. Now, after you documented what the bullet and the fragments look like, did you do certain procedures on the bullet, the larger bullet fragment?
I did, yes.
And what did you do?
I cleaned the bullet jacket fragment, and I also peeled the petals back. If you think of a banana and peeling the skin away from the interior, it's almost like doing that. As you can see from the photo, the petals have been crumpled in on themselves. So in order for me to see the land and groove impressions, which holds those individual characteristics needed for a comparison, I have to do some maneuvering of those petals.
And how do you do that? Do you use an instrument to peel back the portions that you want to look at?
I use pliers.
Okay. And after you did that procedure, did you then photograph the larger bullet fragment itself?
I did, yes.
Were the smaller fragments essentially not of any value to you in terms of doing comparisons?
They were deemed unsuitable, which means there are no microscopic marks of value for comparison.
Okay, but the larger fragment, after you did the process you just explained, you then photographed it again, correct?
That is correct, yes.
Could you display the next page of this exhibit, please? Tell us what we see here.
This is 2 pictures of that 6A bullet jacket fragment after the examination preparation. So the top photo is going to be the interior of 6A, and then the bottom photo is the exterior of 6A.
Now, after you took these photographs, did you proceed to do something to determine whether you had either class, individual, or subclass characteristics.
Yes.
Tell the court what that means.
To start, when I do my initial examination of a bullet jacket fragment like this, I'm going to look at its class characteristics. Class characteristics are the least restrictive set of characteristics I use in my comparison process. And these are design features that are given to a large group of items that characterize them together. So for a bullet, you could think of the diameter of the bullet, the number of landing grooves, the direction of twist, and the type of rifling. So I would go through and look at the class characteristics of this bullet jacket fragment, which was 6 right conventional rifling. Then I'd move on to look at any subclass characteristics. And subclass characteristics are more restricted than class, but less than individual. And they are design features that can be put on an object during the manufacturing process, which is consistent among items that are made by a tool that's in a specific state of wear. So what I mean by that is it's going to be a subset of a larger group, which is why it's not used for for identification or comparison purposes for the basis of a conclusion. But when you think of something that's made through a mold process, when that mold comes together, it creates a seam line, and that seam line is going to be represented on all the items that it makes. So that's why you can't use it for the identification process, because it's going to be on a lot of items, which is why it's a subset of the group. Then I move on and looking at the individual characteristics. And these are imperfections and irregularities that arise from the manufacturing process. And then there's also individual characteristics can arise from wear, use, and abuse of a tool. And these individual characteristics is what is going to be distinct to that tool, and that's why they're used for the identification process. So again, I did an examination of its class characteristics, looked for any subclass characteristics, and then looked to see if there was individual characteristics in the land and groove impressions sufficient enough of marks and values to do a comparison process.
Now, once you have the class characteristics of a bullet, can you narrow the range of firearms that could have fired it just based on class characteristics?
You can, yes.
And is caliber a class characteristic or an individual or a subclass characteristic?
It's going to be a class characteristic because a lot of firearms will have the same class, or excuse me, the same caliber.
Did you measure the diameter of the bullet?
I did, yes.
And did you end up with a range where it could have been a certain range of length or diameter?
I did, yes.
And what was your reading?
Can I refer to my notes, please?
Yes, please.
The range of the diameter for the 6A bullet jacket fragment was .286 to .301 inches.
Okay, what page are you looking at?
It's page 13.
Okay. Now, so this is your documentation of the diameter measurement. And then on the right there, LIMP, that's measurement of the land width,
The
correct?
land impression width, yes.
And these are all general characteristics, or class characteristics, right?
Correct.
Okay. Now, once you had that this, and also that it was, you said, what's called the rifling was to the right, correct?
The direction of twist, yes.
Yeah, the lingo is 6 to the right, meaning,
6 right, yes.
and that's a class characteristic.
Correct.
So once you had the diameter of the base of the bullet, and did you have some difficulty because of the damage to the bullet in exactly measuring it?
The reason I provided a range was because of the damage and deformity to the base. So at times it wasn't a perfect circle, so it was important to me to give a range of what those diameter measurements were.
Once you have the diameter and the rifling characteristics and the land and groove measurements, can you then plug those measurements into a database and to narrow down the class of weapons from which this bullet could have been fired?
The general rifling characteristics search will use those class characteristics and will generate a list of possible firearms that could have fired the bullet. But that list is not all-inclusive, it is just used as an investigative tool.
Sure. Could you go to page 47, please? Could you tell us what we're looking at here?
This is the results of that general rifling characteristic, or the GRC search.
All right, and what did you determine in terms of, just based on the class characteristics, what weapons could have fired the 6A bullet?
There were several different .30 caliber class firearms that could have fired the bullet.
And they're listed here, correct?
Correct.
Could you tell us what the initials PI and RI and PR mean in the far right-hand column?
They refer to different types of firearms, so rifles, revolvers, machine guns, any type of firearm.
And what are the pistol ones? How is that designated? PI or,
Correct.
and what is RB?
Bolt action?
Bolt action. So based on the class characteristics, any of these weapons could have fired that bullet.
They could have possibly fired the bullet jacket fragment, yes.
Okay. Now, let's go back to the examination of the other two measures, subclass characteristics and individual characteristics. Is one of the reasons you look at subclass characteristics because they can be confused with individual characteristics?
That is a concern, yes.
In fact, your manual says that, right? It's important to rule in or out subclass characteristics to avoid the danger of confusing them with individual characteristics.
I'm not sure if our manual says it verbatim. It says that we do need to assess every piece of evidence for possible subclass characteristics.
And what is the reason for that?
Subclass characteristics can be similar to individual characteristics. However, trained examiners are able to notice the difference between subclass and individual. Subclass characteristics are not always present on an item. It's possible, but not always present, and they tend to look a certain way. They're going to be uniform in their appearance. They're going to be spaced in a way that's more uniform. If you think of circles, those circles could be a distance between each other in the same distance every time, and they will look almost the exact same every time.
Now, does your laboratory have certain protocols for conducting these comparisons?
We have procedures for comparison, yes, like taking photographs, yes.
Well, but also procedures for instance, you have a document called Examination and Comparison of Unfired and Fired Ammunition and Components that deals specifically with the procedures to be followed for the kind of examination you did here, correct?
Yes, I believe that refers to the minimal documentation necessary for a piece of evidence.
And one of those standard operating procedure requirements is document observations and evaluate for the potential of subclass characteristics on the relevant tool working surface, right?
Correct, yes.
And you did that in this case, correct?
I did, yes.
Okay. And what conclusions did you reach?
Can I refer to my notes,
Yes,
please?
please.
My subclass assessment that's on page 13 of my report states, stria observed in the land and groove impressions contain starts and stops, are not coarse, and vary in their height, width, depth, and spatial arrangement. No apparent subclass influence.
Okay. And what page was that again?
Page 13.
Page 13. Let me ask you about that. The stria observed are not coarse, I think I understand that, and vary in their height, width, depth, and spatial arrangement. Did you measure the height, width, depth of the land and groove impressions?
The land and groove impression widths, yes, I did.
And how about the striae? That's different than the land and groove impression, right?
Correct, yes.
You didn't measure the height, width, and depth of those marks, correct?
No, I did not.
Okay. And your protocol says, does it not, due to their similarity to and potential confusion with individual characteristics, it is essential that the evidence be evaluated for the potential of subclass characteristics.
It does, yes.
That's the whole purpose of why you're doing that part of the exam, right?
Correct, yes.
And anywhere in your protocols, does it specify what you're looking for, or is it just up to you to decide what is and what is not a subclass characteristic?
Subclass characteristics are a very large part of the training process to become a firearm and toolmark examiner. There are modules that are taught where you're trained to recognize what subclass characteristics look like, what manufacturing techniques might lend to more subclass characteristics. So I am trained to know what it looks like.
Okay, and my question though was, does your standard operating procedure set out, here are the things you should be looking for? For instance, does it say, if what the marks you're looking at are not coarse and vary in their height, weight, depth, and spatial arrangement, or if they're perpendicular on the barrel, that indicates that it's not a subclass characteristic. Is there anything like that in the manual?
No, there's not.
Okay. Did you inspect the interior of this barrel?
I did, yes.
And did you notice whether it had any debris or dust in it?
I believe my notes state that debris and dust was observed in the inside of the barrel, yes.
Okay, and could you further characterize what that was? Debris,
I think it says dust, so I would say dust.
dust. What can cause dust to get inside of a barrel?
A plethora of things. I'm not sure why something is ever in a barrel.
Okay. So you determined here, you ruled out subclass characteristics, correct?
Yes,
Then the next part of the examination was determining whether you had any individual characteristics on the bullet, correct?
yes.
And what did you conclude in that regard?
That there were microscopic marks of value worthy of comparison, or yes, individual characteristics in the landing groove impressions.
And does your standard operating procedure have any guidance in terms of how you go about determining that?
No, I do not believe so.
Okay. And then once you determine that you have items of value on the question bullet, do you then do something to produce test bullets?
Yes, part of the comparison process when there is a firearm that we receive is to test fire it to make pristine samples to see if reproducible individual marks of value is on the bullet or the cartridge cases.
How many test fires did you produce in this case?
I made 3 sets, so 6 total.
Is that your standard number of test fires?
Our standard operating procedures state that you need at least 2. There is not a maximum number that we are allowed to do. It's the discretion of the examiner.
Were you informed by other investigators working on the case that this particular weapon was manufactured in Germany in 1938?
I was not, no.
You did not review a report from an ATF agent who investigated that issue?
No, I don't believe so, no.
In doing your examinations, is it important to know something about the manufacturing process of the weapon?
It is helpful to know how a barrel or any part of the firearm is manufactured, yes.
And why is that?
Certain manufacturing techniques will lend to that individual characteristics. So grinding is a method that is known to leave individual characteristics on a tool. So if a item that I receive, I can tell is finished or manufactured by grinding, it already gives me an indication that individual characteristics would be left from that tool to the tool mark.
Now, once you have your 6 test fires, then you did some comparison between the test fires, right?
That is correct, yes.
And why do you do that?
That establishes whether or not there are individual reproducible marks of value on the test fires. It's important to know that because if there's not reproducibility amongst the test fires, then there's a chance to say, oh, it's not going to reproduce on the evidence and I wouldn't have anything to compare it to.
And have you had cases where you fired the 6 test fires and you don't get reproducible marks?
Not that I can recall.
And when you do your comparisons, just looking at the test fires, do you get situations where there's some dissimilarities between those 2 fired bullets from your test fires?
Yes, there are times there will be disagreement amongst the individual characteristics, even in test fires. You have to think of it as when a bullet travels down a barrel or a cartridge case interacts with a firearm, the marks aren't going to be left onto that item the same way 100% of the time. It's almost like a stamp. If you know you're using a stamp and you put it in ink and then you put it on two separate areas of an item, it might look a little different just from the way the stamp was placed. It's the same thing with a bullet traveling down a barrel or a cartridge case coming into contact with a firearm.
So even when you know a bullet is fired from the same weapon, you can have 6 bullets fired, and when you start comparing them, you will see differences between each bullet.
There is a possibility to see some areas of disagreement. However, if I'm rendering an identification and saying there is reproducible individual marks of value on these test fires, there will be an overwhelming amount of sufficient agreement of that individual characteristic.
Now, when you're doing these comparisons, you use something called the AFTE theory of identification, don't you?
Yes, the AFTE theory of identification.
All right, and take a look. And that's the standard that you used in this case to draw the conclusions that you made in the report that I showed you earlier, correct?
That is the theory stating how an examiner is able to come to a conclusion when examining 2 or more sets of tool marks. And yes, that is how I go through my examination and how I come up with my conclusion, yes.
Okay, and what is AFTE?
AFTE is the Association of Firearm and Toolmark Examiners. It's the governing body of the firearm and toolmark community, whose primary goal is to further research and continue to show information about manufacturing and the evolution of firearm and toolmark examination. They hold annual seminars, publish a glossary of terminologies used by the firearm community, and they also have a peer-reviewed published journal.
Peer-reviewed published journal. Can I join AFTE?
You can, most of the firearms community, or excuse me, members are firearm and toolmark examiners. There are also technical advisors and associate members. Those members are not usually firearm and toolmark examiners, but they still have a livelihood in firearm and toolmark examination, meaning they conduct research or they are involved in products or manufacturing. And anybody is allowed to come to the annual seminar or get the journal. You just have to pay the fee.
Just have to pay the fee, okay. Could you display to the witness Exhibit 27, please? Do you recognize what's displayed here?
It appears to be the AFTE theory of identification, yes.
All right, I move that into evidence, Your Honor.
What is it?
This is the standard that she used to make the comparisons in this case, correct?
Would this be Carner 27
This would be Carner 27, Your Honor.
to the state?
Your Honor, if I may voir dire the witness on this exhibit, I've never seen it before, I don't think.
All right,
Sure.
let's go ahead and do so. Mr. McBride.
When was the last time you reviewed this document?
I'm not sure off the top of my head.
Can you testify as to its accuracy by looking at it now?
Not verbatim, no.
Your Honor, no more questions. My objection is lack of foundation.
Mr. Byrd.
Does this document accurately state what the theory is?
May I take a moment to read
Yeah,
through it?
sure.
I believe something, I think the first statement is different than what I can recall, but overall, it is what the AFTE theory states.
Okay. And your ATF protocol refers specifically to the AFTE theory of identification, does it not?
It does, yes.
Okay. So is there any difference between what's in 27 and what's in your manual?
Again, I don't remember without looking at them side by side.
Okay. Let me get that in front of you. Let's go to Exhibit 12. And go to theory of identification and range of conclusions. Page 1 of 3. I don't have a Bates on it. Toward the end. It's document FT 10. No, that's not it. Can I approach a witness, Charlie?
You may.
Page 1 of 3 of your protocol. I think it was.
I recognize this as something that comes from our SOPs, yes.
Okay. And it refers to the AFTE theory of identification, right?
It does, yes.
Same theory that's displayed in 27?
Yes.
Okay, so I'd renew my offer on 27.
Your Honor, the objection stands. Language matters. Without knowing what, if this language is identical to what she's trained on, that can make a big difference. Whether the word sufficient or adequate is used, these are scientific principles, and we need to be precise in the language that's used. The witness cannot authenticate the exhibit that's been offered, so it should not be received into evidence.
Mr. Burke?
Goes to weight, not admissibility. You'd be free to question her about any differences, but I think she's laid a foundation that the theory's the same, so.
All right. Well, I remind the parties that this is a probable cause finding, and so as it relates to what's been presented, the witness has said that it looks familiar. Again, I don't want to quote you, I don't remember the exact phrase, but she recognized portions of it and then was given the opportunity to compare it to her standard operating procedure. I think she said SOP. For those reasons, Corner 27
Yes,
is admitted and may be
Thank you.
published.
looking at the language of this, the second part of it, according to AFTE, says, currently the interpretation of individualization, identification is subjective in nature. Do you agree with that?
Yes.
Why is it subjective in nature?
The conclusions that I author are of my opinion.
Of your opinion?
Correct.
Does your, you can take that down, thank you. And no, wait a minute, go back if you would. But while he's doing that, does your manual state, what you're looking for under this theory is correspondence of individual characteristics?
Yes.
That the theory is that if you see a certain level of correspondence, you can make a source identification, but not to the exclusion of all other firearms in the world, correct?
Correct.
Okay. And the standard, at least as it's articulated here, is the theory as it pertains to the comparison enables opinions of common origin to be made when the unique surface contours of two toolmarks are, quote, in sufficient agreement. And is a subjective part of that, the quoted part, sufficient agreement?
The subjective part of the conclusion is saying, yes, it is my opinion that there is or is not sufficient agreement or sufficient disagreement amongst two or more tool marks.
And what may constitute sufficient for you may be completely different from the next examiner. Fair?
Yes and no. I would expect any trained, competent examiner to come to the same conclusion. So the threshold of sufficient agreement might be different from one examiner, but the conclusion I would expect to be the same.
Does your manual state, your ATF manual, section 431, state that correspondence or lack thereof of individual characteristics is not easily communicated? An observation such as significant agreement can mean different things to each examiner. This does not serve as interpretable descriptions of what was observed, because the individual performing the review will likely have his or her own concept of the phrase based upon their training, experience, and knowledge.
Objection, Your Honor. This question goes to weight. Oh, I'm sorry. You don't, may I be heard?
If you're objecting, I will hear the objection.
It's just speaking objection. That's why I stopped myself. This goes to weight. This goes to credibility, and the witness's report has already been admitted as is appropriate under the Utah Constitution, Rule 7B and Rule 1102 of the Rules of Evidence. This is beyond the scope of preliminary hearing for those reasons.
Mr. Burns.
Number one, that's a general objection, which I think has been waived. The state was privy to the interview with this, pre-hearing interview with this witness where these same questions were asked. We had a scheduled hearing where the court was going to rule on objections. The state indicated in advance of that hearing that it had no objections to the testimony, reserving the right to make particular objections. But the objection being made is a global one. And it's relevant because the state offered, the evidence I'm offering here is relevant because the state offered through a hearsay declarant the meaning of this report that this examiner authored. And I'm trying to inform the court on what the limitations are of the opinions expressed in the report that the state offered. And it's certainly relevant to the reliability issue to know that the opinion is based on a subjective standard that the witness herself admits is subjective. So I think it helps the court understand what weight, if any, to give to this report that the state offers.
All right. Mr. McBride, final thought.
That's all fine, but it's inviting the court to weigh the evidence. That's the whole point. And at this point, the inferences are drawn in the state's favor, and the court is not to weigh even contrary evidence.
Okay. Well, in regards to whether objections have been waived or not, the court as the magistrate bears the ultimate responsibility to ensuring that this hearing is a probable cause standard. And so that's a responsibility that as a magistrate I take seriously. I understand the arguments from the parties. I'm going to overrule the objection, but Mr. Burt, this is, we don't need to go 100 miles down a path where 1 mile is where probable cause may be. And so I invite you to refocus, to bring it
Sure.
to the probable cause. I'm not trying to limit what your theories or such, but I need to hold to probable cause.
Absolutely, and I don't even need a quarter of a mile. This is my last question, and I'm going to move to another
All right.
topic.
Thank you, Mr. Burt.
Is that what your manual states?
I don't remember it verbatim, but it does sound accurate.
Well, could you pull up Exhibit 12, page? Just to, can I approach again?
You may.
I'll give you the 2 pages quicker. Bottom of the page, highlight.
I see where you were reading from, yes.
You see,
Yes,
did I accurately read it?
I believe so, yes.
Thank you. Can I approach again?
You may.
Okay. Now let's return to the report, the People's or State 32. And if you would go to the second page, please. You concluded here, did you not, that the Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1A based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics? The result of the comparison was inconclusive.
Yes,
That was your ultimate conclusion, right?
yes.
And on the next page, if you could go to 2 pages in, you have an appendix, do you not, where you explain what inconclusive means? Next page, one more. There we go. I want to ask you, because I'm unclear on what inconclusive mean. You say, reasons for an inconclusive or include the presence of microscopic similarity that is insufficient to form the conclusion of source identification, a lack of any observed microscopic similarity, or a microscopic similarity that is insufficient to form the conclusion of source exclusion. Could you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion, it was insufficient to form a conclusion of source exclusion?
No, my conclusion is inconclusive, just as it says in the appendix. There is a lack of sufficient agreement and sufficient disagreement, so I'm unable to say one way or another.
Okay, but I guess my question is, were there points of dissimilarity between the question and the known bullets?
Again, there was sufficient agreement and there was not sufficient agreement or sufficient disagreement. So yes, there was times that I saw agreement in the striations and the land and group impressions, also seeing disagreement, but there was also a lot of lack of microscopic marks of value to see it all. So because of this lack of quality and quantity of marks to be able to see, it never reached the threshold of sufficient agreement nor sufficient disagreement. So an identification or exclusion could not be rendered.
Okay, I think you and I have met before today, correct?
Yes,
Where we talked about what that term inconclusive meant, correct?
yes.
And I think, and correct me if I'm wrong, but did I read to you from a do you recall me asking you whether you agreed with this statement, that an inconclusive conclusion indicates that the microscopic marks in question may or may not have originated from the same or known source?
I do remember you asking, yes.
And you agreed that that was a correct definition of what you concluded in this case, correct?
Correct, yes.
Okay, so I want to, if I could, return to 10, Exhibit 10. And in Exhibit 10, not 10, I'm sorry, your case file again. This is the 47-page document. There we go. What's the tab? 6. Okay. In your case file, you have produced for us some nice comparison photos of your comparisons, correct?
Yes.
Okay. And if you would go to page 37. Is the top photo depicting one test fire on the left and another test fire from the same gun on the right?
Yes, it is.
So do you see areas of agreement and areas of disagreement in these two bullets fired from the same rifle?
I see sufficient agreement amongst the striations that are in this land impression.
Okay, and tell us where they are. When you draw that conclusion, using this subjective theory of identification, show us what you're looking at.
Is it touchscreen?
Probably,
No, it's,
No.
I'm sorry.
but we can, if you direct us, we can get there with a pointer.
Sure. So you can see towards maybe the last third of the bullet or the land impression that, yes, right where your cursor is below there, that's an area of agreement with that striation. It looks like it's going from the left to the right, so that mark is appearing on the test fire on the left and the test fire on the right. Then if you look towards the top of that land impression, there's going to be some more lighter colored striations or lines that are moving from left to right. Those areas are in agreement as well.
Where is that? Not as far up as where he is, correct? It's down?
Yes, and I believe the PowerPoint that I provided does have some areas and circles of some of these marks, if that would help as well. But if you move your cursor up, continually up, keep going. There you go. You have a line that was right there, and you have several others underneath of it that looks like it's going just straight across from left to right, and that shows an observed area of agreement.
So that one he's got circled on the right, I see a line there. Are you saying you see a line on the left that it's identical to the one on the right?
I'm saying I see agreement amongst those striations, yes.
Okay, anything other than those two areas?
You can really go down the entirety almost of that line looking at those striations. So under the top red circle, there's another area there. Yep, if you start right there and you draw your circle over, like I said, at the top of the circle, there's a highlighted line on the left that goes all the way to the right. If you go a little bit farther down, maybe still in the top third of that circle, you can see another line going from one side to the other, another area of agreement as well. And then under the final third circle, in a little darker area down there, there's still some lines, again, in sufficient agreement.
Okay, and again, these are comparisons between test fires. So you know the rifle that you're test firing fired these two bullets, right?
Yes, and the
Okay.
purpose of those test fires is to ensure that though it was fired from the same firearm, you want to make sure that those individual characteristics are reproducing.
All right, so go to the photo on the bottom of that page. This is the first of several comparisons between the test fire on the left and 6A on the right, correct?
Yes.
And what does the writing on the top mean, blue index GIMP?
So that will be, the first number there is the case number, the laboratory case number. Then next 1.11B is going to refer to the specific test fire that's on the picture. And then V versus 6A, so that's the evidence that's also pictured. GIMP stands for a groove impression, so I'm looking at a groove impression in this photo. Blue index means I'm specifically looking at the groove impression that I have put a blue indexing mark on so that I know where I am during the comparison process.
Okay,
30X refers to the magnification that the photo was taken at, and then INC refers to inconclusive, the final conclusion.
so I'm interested in the areas of disagreement. Are there areas of disagreement between the known and the unknown here that you could point us to?
So for this photo, to me, I see areas of agreement in the top. And then on the way down from the 6A, right after you see those two highlighted lines near the top, there's a lot of damage that is observed, and almost no microscopic marks of value can be observed at all. So again, that lends to the lack of quality and quantity of marks even to do a comparison. It's almost like missing data points.
Okay, missing is not the same thing as dissimilar though, right?
It just means there's nothing there to call agreement or disagreement.
So do you see areas of disagreement here or no?
On the striations that are available to me on this groove impression, I see areas of agreement, and specifically talking about those two highlighted lines at the top on the right.
Okay, go to the next page, please. Top photo on the next page. It's B38. You see areas of disagreement in this photo.
So this is the same photograph that we looked at before, just at a different magnification. It's zoomed in a little bit more from 30 to 40x. So again, I'm looking at those two highlighted lines near the top, and then if you look down, you can almost see that damage a little bit better, and there's none of those striated lines that you see on the test fire, which you would expect to see in a land or groove impression on the right at all. So again, no microscopic marks of value to compare whatsoever.
All right, how about the bottom photo? And again, the question, areas of disagreement.
The possibility of an area of disagreement maybe in the middle. There on the 6A is a line that does not look like it carries over, but just from this snapshot, I cannot say if I had moved the photo a little bit different or the specimens together, that area would be agreement. In this photo, it does not look like it does, though.
Okay. And could you go to the next photo, please? Same question here, areas of disagreement.
The way this photo was taken is highlighting more of the lack of microscopic marks of value. If I had pulled the specimen that's on the left, the test fire over, there might be some agreement that could be observed, but the way the photograph is now, you don't see the line on the right going all the way over. But again, this is just a snapshot of one particular area.
Doesn't show areas of agreement or disagreement.
There is an area of agreement at the very bottom of the photo.
Okay,
Correct, yes.
next photo, please. How about this one?
This is another zoomed in of the previous photo, focusing in on that bottom area of agreement. So we went from 30x to 40x and just highlighting one specific area, and this is showing you agreement.
Next photo.
So again, this area that is highlighted, the bottom portion that's in focus, is showing an area of agreement. As you go up, the lines are a little bit blurred on the 6A bullet jacket fragment, so it's hard to say if that area was an agreement or disagreement. That's not what my photo was focusing on.
All right, next one.
So again, this is going to show you part of the groove impression at the white index. On the top, you can see some striated lines, or excuse me, more of the middle of the photo. The top of the groove impression from the 6A, you see some lines that do not appear to be on the right side either, but this photo is also trying to show the lack of microscopic marks at all towards the bottom of that groove impression.
Okay. But there are in these photos areas of disagreement as well as areas of agreement, correct?
In the photo that we just looked at, it could be possible areas of disagreement. Again, it's just one area that I'm looking at. It's hard to tell when you can't look at the entirety of the land in this
Sure.
moment.
Now this, you can take that down, please. Do you keep up with the literature relevant, scientific literature relevant to your field?
I do, yes.
And are you aware of certain criticisms that have been leveled against this AFTE theory of identification?
I have heard, yes, I've heard recommendations on how to improve the AFTE theory of identification, yes.
Well, the criticisms have gone beyond that, right?
Specifically, what are you referring to?
Well, you're aware that the National Resource Council,
The National Academy of Science?
National Academy of Science,
Yes,
is that a pretty preeminent scientific organization in this country?
yes.
Did they conclude in 2009 that, quote, a fundamental problem with toolmark and firearm analysis is the lack of a precisely defined process? As noted above, AFTE has adopted a theory of identification, but it does not provide a specific protocol. It says that an examiner may offer an opinion that a specific tool or firearm was the source of a specific set of tool marks or a bullet striation pattern when, quote, sufficient agreement exists in the pattern of two sets of marks. It defines agreement as significant when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. The meaning of exceeds the best agreement and consistent with are not specified, and the examiner is expected to draw on his or her own experience. This AFTE document, which is the best guidance available for the field of tool mark identification, does not even consider, let alone address, questions regarding variability, reliability, repeatability, or the number of correlations needed to achieve a given degree of confidence.
I do remember
Objection,
there's.
objection. We're now firmly into 702 territory. I object on grounds of relevance to the probable cause hearing and beyond the scope of the PC hearing, as I previously objected.
I think
Mr.
it
Burke.
goes directly to reliability. That a scientific group studied this exact process that she used in this case and reached that conclusion.
If you would, so, again, I'm trying to keep us on the probable cause standard. This is going a bit deep in regards to it. This is citing to 2009, and so we're in 2026. And again, I don't want to have to dive deep into areas trying to determine, because I feel that we are exiting the orbit of probable cause. If I'm having to make that analysis and trying to see, like, how is this relevant? How does this apply? How does this go to probable cause? So if you wish to ask this question and then move on, we certainly could do that, but
Sure. The only thing I wanted to do was establish that this was the foundation criticism in 2009. And I know when we had raised this issue with respect to one of the other experts, the comeback was, oh, well, this was in 2009 and the PCAST report was in 2016. In this particular field, these criticisms have started in 2009, but they have continued up to the present day and have gotten more strident. So I think that's the take home here, is that this is not some past criticism that has been set aside. This is a criticism that this expert is aware of and that has continued in the literature up to the present time.
But I don't have that second portion of what you just said in front of me. So I can't agree with you, because what I have is what's before me. I can't go searching myself as a magistrate for probable cause. I have to take what you say as it is. And if I have to start searching, I've left the universe of probable cause.
I agree, and I was offering that to the court as a proffer in
Okay.
terms of where this line of questioning is going, so the court can understand the context.
Okay.
It isn't just an isolated criticism, and I'll establish with a couple of questions that it's continued up to the present time.
So I will overrule the objection, but I will limit you to this question. We're going to more and more and more I see your point. You're looking at whether this science is challenged or not. The point's been received, but anything further goes outside of probable cause. So we have to get back on the path.
Got it.
Thank you, Mr. Burke.
You're aware of that criticism, right?
Yes, I am.
And you're also aware of the criticism leveled in 2016?
Counsel, I just said that we're focused solely on, I've accepted what you've said, but I said that it's limited to this question, and then we're moving on, because anything further is going outside of probable cause.
I misunderstood. I apologize to the court.
And I
thought-
apologize if I wasn't clear on that, so maybe it was my error not communicating. I've accepted that coming in, I've overruled the objection, but I said, we're gonna leave that where it is and then move forward.
And that's where I'm unclear. When the court says move forward, no more questions about any further criticisms beyond that one? If that's,
On this line of question, that's correct. Because
Okay.
Thank you,
All right.
Mr. Burke.
and I think I've made the proffer in terms of the relevancy of it. The
And
court is-
I accept that, so thank you, Mr. Burke.
All right, then the last area is In the years that you've been doing this testing, is it true that you've only taken one proficiency test that involves bullet comparisons?
Yes, I've only had the opportunity to take one bullet proficiency test so far.
And is it true that that was in 2023?
I don't remember the exact year, but that sounds correct, yes.
Right. And is it true that that proficiency test involved a test where you had question bullets, and then you had two sets of bullets, one that was fired from one gun, not the suspect gun, and then a second gun that was fired from another gun?
I don't remember the exact final ground truth answers that were there. No, I'm sorry, I don't remember.
I think when you and I talked about this, you said you were aware of a controversy about that particular test, correct?
I was aware, yes, of the results of the proficiency test, yes.
That there was a very high error rate in that particular proficiency test, right?
There was a higher error rate, yes. However, my answers were satisfactory, along with the 5 other examiners at my specific laboratory that took it as well.
Your conclusion in that case was, as in this case, that it was inconclusive, correct?
Correct.
Even though the correct answer was that the bullets did not come from the question, the two did not match, the known in the question should have been an elimination.
The ground truth answer was yes, they were excluded. However, an inconclusive result in this comparison was extremely appropriate. The lack of quality and quantity of those individual characteristics never reached sufficient agreement, nor did it ever reach sufficient disagreement. So saying anything but inconclusive was not appropriate.
I see. And can you have bullets fired from different weapons that can have individual characteristics that look pretty similar?
There is occasions, yes, that tool marks that are made by 2 separate tools are similar, yes.
Could you go, and this is my last area question, Exhibit 19, page 26?
Your Honor, I'm requesting
Page
20 minutes
26.
for cross-examination. We're coming up on 4:37. That would be my request, Your Honor.
This is my last question. So,
All right, Mr. Burt. Thank you, Mr. McBride. I appreciate the heads up.
in your opinion, does this, the one on the left and the right, show matching individual characteristics?
Counsel, has this been admitted? Because I see it displayed. I just want to make sure, is this?
It has not been admitted, and
Okay.
I'm asking this question and as a foundation for admitting it.
Okay, that's fine. So I just
Yeah.
want, it was on another screen. I wanted clarification, so it's not on any screens because it hasn't been admitted, but clearly it can be on her screen.
Thank you.
So only to the witness and counsel table screens.
Page, Exhibit 19, page 26. Does this comparison show individual characteristics indicating that it was fired from the same weapon?
There are individual characteristics present, but without examining it in person, I don't feel comfortable making a conclusion.
Okay, how about the next page? Watch, 27. How about that one?
Again, I see individual characteristics. On a very first glance, I can see maybe one striation that is an agreement, but without seeing it physically in person and having an accurate representation of the entirety, I can't conclude in any answer.
And the last one, the third photo, page 28. Page 28. Exhibit 19, page 28. Same question.
I do see individual characteristics. I do see some areas of agreement without looking at it further. I wouldn't make a conclusion. It's a holistic approach when you're examining items.
Would it surprise you if I told you that all three of those were fired from different weapons?
Again, I don't know any context to these photos other than what you showed, so I don't feel comfortable saying one way or another.
Thank you.
All right. Mr. McBride.
Good afternoon.
Good afternoon.
Those last three photos that you were shown, had you seen those before?
I had looked at them probably back in 2024 when it was published.
Okay, that's a study, is that what that is? Of some sort?
Yes. It was a look from the Association of Firearm and Toolmark Examiners. It was a volunteer of photographs of people that did have an incorrect answer in that proficiency test.
Okay. And when you do an examination or a comparison, are you limited to one photograph?
No,
You actually have the item in front of you, correct?
that is correct, yes.
And you can manipulate it, you can turn it, you can look at every angle and every side of that item as you do the comparison, is that correct?
Yes, that's correct.
And as you're doing that process, you're looking for as many characteristics that match or agree or disagree as you can possibly find, correct?
Yes, it's a holistic approach. If I have a bullet like this case, I'm looking at every single land, every single groove impression, and doing an evaluation of each one of those, looking for areas of agreement and disagreement before rendering a conclusion.
Would it be responsible for you to reach a conclusion based on a single photograph of a very limited area of two bullets?
I would not feel comfortable doing that now.
Okay, I want to back up. How long have you, first of all, where do you work?
I work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
How long have you been there?
A little over 6.5 years.
Where did you come from? Where did you work before that?
Prior to working for ATF, I was a latent fingerprint technician, recovering latent fingerprints from improvised explosive devices, and I also worked as a crime scene investigator in Winston-Salem, North Carolina, and Anne Arundel County, Maryland.
How long did you have that position?
I think cumulatively it was about 5 to 6 years.
And before that?
Those are the only ones. I think it was about 6 months as a latent fingerprint technician, 2 years as a crime scene in Winston-Salem, and 3 in Anne Arundel County.
Do you have education and training before that position?
Yes, I have a Bachelor of Science in Forensic and Investigative Science from West Virginia University and have attended and graduated the National Firearms Examiner Academy, as well as done specific training at my laboratory.
At each of the positions you've held, have you had on-the-job training at the laboratories where you've worked?
I have, yes.
And will you describe what that training is like at the ATF where you are now?
Yes, so part of becoming a firearm and toolmark examiner for ATF was attending the NFEA, the National Firearms Examiner Academy, which is a year-long intensive comprehensive training program. I learned about historical cases, figures, and the evolution of firearms, fired ammunition components, and manufacturing. In phase 2, I worked 16 weeks of hands-on experience assembling and disassembling firearms using a comparison microscope comparing fired ammunition components and tool marks, going on manufacturing tours, and participating in moot court. I worked on an independent research project and 4 practical exercises, and then presented that independent research project to a panel of experts and participated in 2 moot court sessions on 2 of those 4 practical exercises. Then specifically for ATF, I still work on my training, going through practical exercises and competency tests, working under trained firearms examiners at my laboratory, and also continue learning about any manufacturing evolutions or going on manufacturing tours. And I also participate in moot court for every single competency test that I work. Once all of that is complete, then I work on supervised case before moving on to unsupervised casework.
And supervised casework means what?
It means that the author of the final report will be a different examiner, but I am working on all of the work side by side and going through all the steps that are needed for that examination.
And in that process, you're having discussions and discussions about your work with a more experienced examiner.
Yes, it's an opportunity to work a case that has come into the laboratory, but still have someone there making sure I feel comfortable with everything and following every step necessary.
How long ago was that you had that, that you graduated from that supervised work?
I believe that was in 2022 or 2023. I'm not sure.
Do you supervise now others?
I do not have a supervisor capacity, but I have had the opportunity to now teach at the NFEA. I've been fortunate enough to participate as an instructor in the test firing module, the mini moot court module, and the comparison of bullets and cartridge cases.
Are you required to undergo continuing education in your position?
There is not a specific continuing education program. However, when the opportunity to go on AFTE's annual conferences and it allows it, I will go to those, as well as continually go to manufacturing tours.
Is this an area of science and forensics that is continuing to develop new techniques and advance in research?
Yes, it is.
And how do you stay up on those advances?
Part of the way to do that is to continue my membership with AFTE. Again, they do an annual training seminar recently, just in May of 2026 here in Baltimore, where there's case searches and studies that are presented, different manufacturing techniques, just new and upcoming research that is throughout the community, not just firearms practitioners, but also standard and technology researchers like those from the National Institute of Standards and Technology, or NIST.
And I think Defense Counsel has asked you a little bit about some of the publications that have given criticism is how he's phrased it, but given recommendations on how to improve the science in your field. Are you aware of that?
I am, yes.
And is there an effort to adopt those suggested improvements where they have merit?
Yes, AFTE especially takes those recommendations very seriously. If the PCAST asked for more specific design test studies, they said, yes, we will do that. I can think of just a few right off the top of my head that has satisfied those asks that they wanted.
Is your laboratory accredited?
It is, yes.
What does that mean to be accredited as a laboratory?
And accreditation means that my laboratory is held to an international standard of reporting, testimony, training, and proficiency tested. We have a large audit every 4 years through ANAB, or the American National Standard Institute, National Accreditation Board, but we also do internal audits, and we make sure there is some type of audit that we are staying in within those accreditation limits every single year.
There is a mention of proficiency testing. Are you required to do proficiency testing?
Yes, I am.
And are those specific as to what type of proficiency testing that you do?
Yes.
What are some examples?
We are required to take proficiency tests in all discipline that our scope enables, so serial number restoration and the comparison of tool marks, bullets, and cartridge cases.
Are there similarities and principles that apply to all aspects of tool mark analysis and comparison?
Can you elaborate on the question, please?
Well, let's say you're comparing what we've been talking about here, rifling on a bullet. Are there principles that apply to that area versus that also apply in tool marks analysis, say of impressions of a handheld tool?
Yes, all of those comparisons are a product of a tool mark comparison. A firearm is nothing but a tool. So when you are talking about a cartridge case comparison, it's still looking at a tool and a tool mark. The tool in this case is the firearm. The tool mark is being left on a cartridge case or a bullet.
I want to draw your attention to Plaintiff's Exhibit 32. Thank you. Well, that's pulling up. And this has been published, has been approved for publication at all 3 levels already, so we can put that on the screens. While that's pulling up, thank you. I want to ask you first about an entry here. The second sentence under results of examination. Exhibit 1 rifle was test fired and found to be in operable condition. Did you perform that test fire?
I did, yes.
How did you receive this firearm?
I received it from another physical scientist in our laboratory.
Okay. And did it have a scope on it?
Yes, it did.
What did you do to determine if it was in operable condition?
In order to determine if the firearm is in operable condition, I will find ammunition that it is calibered for. In this place, it was 30-06 Springfield. Load that into the firearm, and then I fired any test fires into our water recovery tank.
Okay. And why did you choose a water recovery tank?
The water recovery tank is what is used to obtain bullet specimens. The water is going to slow down the bullet from its movement so that we can actually obtain the bullet, and it is supposed to cause minimal damage.
Why does it matter if there's minimal damage or more damage?
You would like minimal damage because that means that there's going to be less damage on the areas that you need to compare.
In the evidence rounds that you, or in the bullets that you often receive in your cases, are there cases where there's a lot of damage to those bullets?
I have received cases with lots of damaged bullets, yes.
In this circumstance, the Exhibit 1 rifle, this Mauser 98 30-06, was it an auto-loading rifle or a bolt action?
This was a bolt action rifle.
Exhibit 2 cartridge case, let's see here. If you'll turn to page 2, and we've already read this line, I think defense counsel read this line to you, the Exhibit 6A paragraph there. The result of the comparison was inconclusive. Could further testing be done to try and see if there is any, if you come to a conclusion on this round?
There was no further testing that I could do, no.
Is there further testing that could be done in the field?
There is the possibility of using a 3D system to visualize the individual characteristics on the bullet.
Do you have the capability of doing that at your lab?
My laboratory currently does not have that capability.
Do you know if the FBI lab does have that capability?
I believe they do.
Defense counsel put up a list of potential firearms that could have fired this round, or this bullet. Is that list comprehensive?
It's not an all-inclusive list.
And does it mean that this round, I'll leave it at that actually. There's been some discussion about the 6A bullet jacket fragment. Will you describe what a bullet jacket is?
Yes, I do have a demonstrative. May I use that?
Do you have that with you?
Yes.
Yes, please, go ahead.
So this is a demonstrative of a bullet. So a bullet jacket, it would refer to the outside of the bullet. Inside the bullet would be the lead core. So when I'm referring to the jacket, it means that I've only received that outer portion. I did not receive any of the lead core intact with it.
In this circumstance, you received a bullet jacket fragment. What does that mean that it's a fragment?
Fragment means I don't have the entirety of that jacket.
And can you testify as to why you don't have that entirety?
No, I cannot.
And it also, your report also says that there are 4 lead fragments. What is this? Why would you have lead fragments?
So the lead fragments, the lead would be from the inside of the bullet, that core. Occasionally when the bullet reaches its final destination, it can split, and some of that core might be pulled off of the jacket and be found where it landed.
And would you be able to gather information from those lead fragments that could identify them as coming from this particular firearm? Would you expect to be able to make that comparison?
I would not expect to see any characteristics that would help me reach a conclusion, no.
Why not?
Because the lead core is on the inside of the bullet, the landing grooves are going to be imparted onto the jacket or the exterior. So when it's moving down the barrel, the inside is not coming into contact with rifling whatsoever.
In this case, do you have a verification step where your work is reviewed by another analyst?
We do, yes.
And were your conclusions in this case verified by another analyst?
Yes, they were.
Is there a potential that the testing you do can destroy the evidence that you're reviewing?
What do you mean?
Well, prevent it from being tested in the future.
No, I would not expect anything that I've done to prohibit more examination in the future, no.
But in general, you say you peeled back the petals, I think you said, of the bullet jacket because it was so crumpled. If that's,
Yes. I think if anything that lends to a better comparison process. It is a very well-known practice amongst firearm and toolmark examiners. Without doing a examination like that in preparation, no one's able to see the marks that are needed for the comparison process.
Okay. In reaching the conclusions that you did in this case, did you follow protocols and practices that are required by your position?
I did, yes.
Nothing else?
Mr. Byrd.
You said a couple of things of interest to me. One was that your work is peer-reviewed, right? There's a peer
Specifically?
reviewer, a second reviewer,
It is a verification process.
verification process. And you know, in this case, we requested to produce the case file from your reviewer so we could see whether it was accurate or not. You're aware of that, right?
I am not, and the verification process does not require that the verifier has case notes. Their case notes would be within mine, and it's just an author verification chart.
Well, you wrote a memo to Mr. McBride dated May 19th, did you not, in which you said in answer to our request for the reviewer's work product that ATF laboratories do not release materials concerning technical reviewers or verifiers. And you went on to state, did you not, that we don't even release the CVs of who the reviewers are.
So that is not authored by me, that is our ATF procedures and protocols. If that was an email that came from me, I am just verbatim what our quality assurance manager has said.
Do you think science works best when it works in secret?
Objection, argumentative.
Counsel?
It goes to the issue that was raised on cross-examination, which is my work was peer-reviewed. So how do we evaluate the strength of that assertion when they refuse to hand over to us the work product of the reviewers, or even identify what their credentials are? That's relevant.
Well, I'm not agreeing or disagreeing with that, but the question itself was argumentative. Because we can look at the question, working in secret
Let me
is...
rephrase.
Okay, so I am going to sustain the objection. Because of the phrasing, it is inherently argumentative, and it wouldn't be a question that would be able to proceed into prelim.
Do you have an opinion on whether it is scientifically defensible to rely on a peer reviewer and not reveal that peer reviewer's work product?
believe I understand what you're asking. However, in this case, the verifier does not have any work product to show. If you'd like to see their CV, I cannot testify to anything about the procedures of giving their information out. All I can say is that they are employed at my laboratory, are under the same scrutiny of proficiency testing, went through the same training with competency and practical exercises, so they are a trained and competent examiner.
They don't have any work product to show, but your protocol calls for, does it not, documentation of whatever it is they did?
And that is included in my case file.
Right, but not the reviewer's work product.
The reviewer's work product is a verification sheet. If you'd like, I can refer to my case notes and find that specific page number, but that would be the only work product that they would have in this case.
I see. Now, you said two things about the PCAS report on cross-examination. One was that, if I understood it, that the PCAS findings have been addressed in subsequent studies. Did I hear that correctly?
Because one of the recommendations was to further, actually, I think their recommendation was one more black box study to show the foundational validity of firearm and toolmark examination, and since 2016, several have been published.
All right, let's look at that for a second. First of all, they didn't recommend, they found, did they not? Quote, PCAS finds that firearms analysis currently falls short of the criteria for foundational validity because there is only a single appropriately designed study to measure validity and estimate reliability. The scientific criteria for foundational validity requires more than one such study to demonstrate reproducibility. Isn't that what they found?
That is what their finding was, correct.
Okay. And then after that report was published, in 2017, they came out with a second report because people said, oh, the literature already exists, you missed it. And they said, no, that's not true. Isn't that right?
They
Objection,
concluded,
relevance to preliminary hearing, we're now well into 702 argument.
He raised this issue on cross, Your Honor. He clearly went beyond the 2009 reference that the court allowed and opened this area up. And I don't think it's fair for him to be allowed to do that without me being able to respond to it.
Thank you. On cross-examination, that door was opened by the state, and so I will allow limited questioning on recross or redirect, however we want to label this. So you may proceed. The
Thank you.
objection is overruled.
In 2017, they filed a second report responding to assertions by people in your profession and others that they had missed or the studies had already been done. Isn't that true?
yes, PCAS did a 2017 addendum to their 2016 report, reiterating that they believe that the only way to properly empirically test a science is through these black box studies, and that they would not take into consideration the numerous amount of work and validation studies done over decades that the firearms community has published.
And a bunch of other studies were done, right?
Correct.
And in response to those additional studies, there have been continual criticisms of the methodologies of those studies. Isn't that fair?
Yes.
And you've read, for instance, well, first of all, you attended, I see, a webinar by the group that did some of the critiques. Remember that?
Which webinar are you referring to?
You attended a webinar, I believe, in 2023, Treatment of Inconclusive Results and Error Rates of Firearm Studies. Webinar hosted by the Center for Statistics and Applications in Forensic Evidence, 2021,
Correct, I did.
according to you. And that group has published a number of studies right up to 2026, for instance. Their study in 2024 called Methodological Problems in Every Black Box Study of Forensic Firearm Comparisons, in which they concluded that the field still was not reliable despite the studies that you reference. Isn't that true?
That is the author's opinion, correct.
Right. And they're not the only ones. There have been other groups of statisticians who have published articles right up to 2026 saying that the studies that you referenced are unreliable. That their
Yes.
methodology of those studies is flawed and cannot be relied upon to support the science of toolmark comparison, correct?
Yes, there has been studies to say that they believe there is flaws in the black box studies and stuff, but there has also been plenty of research done to say the opposite.
And lastly, you mentioned that, or it was brought out that you have training and experience, right?
Correct, yes.
Do you agree with the conclusion stated in the section of the report, the PCAP report, that neither experience nor professional practices can substitute for foundational validity? Do you agree with that?
I do, yes.
You agree with the conclusion reached in the PCAP report that a forensic science discipline that has an error rate higher than 5% is not reliable?
I don't know that I have opinion to that because I think it's a little on the broad side. I don't know what you would consider high as far as a percentage.
Well, I'm referring to the statement at page 151 where they say methods with a high false positive rate are scientifically unreliable for making important judgments in court about the source of a sample. To be considered reliable, the false positive rate should certainly be less than 5%, and it may be appropriate that it be considerably lower depending on the intended application.
I would agree with that statement.
You would agree with that. And you also lastly reference your knowledge of the study by the AFTE of that proficiency, the one proficiency test which you have taken on bullet comparisons, correct?
Correct.
And the error rate in that particular study, proficiency test, was 20.4%, correct?
Correct.
For item 2, 18.2% for item 3, and 18.9% for item 5.
I believe those were the results. However, I don't agree that proficiency tests are what are used for validation studies to show foundational validity.
So
Proficiency,
if the error rates are high, then they shouldn't be relied upon to show invalidity, but they should be relied upon to establish that your experience means that your science is valid? Is that what you're saying?
foundational studies are looking at, just as PCAS said, those black box studies, different test design, all of which firearm and toolmark community has conducted. We've looked at cartridge cases, bullet, pristine samples, damaged samples, and different firearms. Proficiency test is looking at the accuracy of an examiner's results, not foundational validity.
But you would agree that an error rate of 20% is unacceptable, would establish unreliability, correct?
I would agree that those results need to be looked at to see where that error was coming from.
Right, okay, thank you.
Thank you. Anything further for this witness? And Mr. McBride, I'm going to limit you because your objection to going outside and going to 702, you opened the door, but I've got to close that door to some point. So I will give you a limited number of questions. We need to come to a close.
I understand that. Your science has been accepted by courts across the country, correct?
Correct, yes.
It's routinely admitted in courts across the country, correct?
That is correct, yes.
Your science has been peer-reviewed and viewed favorably by numerous publications and studies across the country and across the world, correct?
Correct, yes.
No more questions.
May this witness be excused. Thank you, Mr. Burt. Thank you, Mr. McBride. Ma'am, thank you for being here. You are excused. All right, that brings us to a close. Do either party wish the benefit of the record before we adjourn for the night?
Your Honor, can you just give us about 5 minutes, and then I think we can make an announcement. Can you just give us a minute to chat?
Yes, you may have that, and we'll stay in court for these 5 minutes, just because we're live. So court is back in session. All the parties are present, except for maybe one attorney. Mr. Grunender, should we wait for counsel?
Take maybe 30 seconds to wait for Mr. McBride.
All right, we'll wait for Mr. McBride. I just want to ensure all the attorneys are present. All right, I note the presence of all attorneys. Turning to Ms. Nestor.
Thank you, Your Honor. Your Honor, we have just one more witness who would be a fairly short witness, not super long. So I anticipate we will be done tomorrow, probably by lunch, I would think. So maybe if we could plan that we'll be finished. We probably will not need the entire day tomorrow,
Thank
is
you,
my
Ms.
suggestion.
All
Yes.
right. Turning to the state, obviously, I'm not holding you to your answer today, but just for guidance, does the state anticipate and rebuttal witnesses?
Judge, we don't anticipate any rebuttal evidence that needs to be presented to this hearing. So I think the question would be is, are we going to argue the bind over tomorrow? And the state would be prepared to argue bind over tomorrow.
All right, well, I appreciate that. In regards to trying to budget time here, how much time does the state anticipate? Obviously, there's one more witness, so I'm not gonna,
If it's a short witness, Judge, I don't think it should take us the entire morning. But we would be prepared to argue tomorrow morning at the close of evidence or first thing in the afternoon.
And how much time do you anticipate that argument being? Again, a rough estimate, I'm not holding you to the exact number. I'm just trying to see how close are we to the 5 o'clock, because I'm gonna ask the defense the same question as well.
It wouldn't come close to the 5 o'clock hour, Judge.
For just you or for both?
For argument,
Yes.
both of us.
Okay, all right, well, I'll turn it, thank you, Mr.
If we have to argue 2 hours apiece for bind over, there's a problem.
All right, thank
I
you,
would say
Mr.
that.
Fernando.
Thank you.
To the defense, I'm just getting an estimate, I'm not holding you, I'm not gonna time you to this, but I'm just trying to see as it relates to 5 o'clock and for argument for bind over tomorrow afternoon.
Understood, Your Honor. Our request, the defense request, is that we be allowed to submit briefing. There are some legal issues that we would like to brief for the court prior to the decision on the bind over. We're open to briefing page limits, time limits, all of that, but we would like that opportunity because there are some legal complexities involved here.
All right, and if, and I'm gonna ask the state, but if the state, well, I'm not gonna assume anything. Thank you. So
I
are you-
believe the state is going to object to that, Your Honor.
So what I hear you saying is you wish to, well, I don't want to assume, what it seems like you're saying, I want to be clear, is you're waiving oral argument and just doing briefing.
So generally, Your Honor, in cases with multiple counts that are pretty complex issues of law, I have asked for briefing and the opportunity for an argument. We can set time limits on that as well prior to bind over. I've done this in multiple other cases before courts in Utah. And that is my preference, to make sure we get the law right.
And so how much time, if you're asking for argument, that in addition to briefing, I'm trying to get the
Sure.
total universe of what's in front of me.
So I anticipate that, I agree with Mr. Grunander that I don't think an argument would take more than a half day. Should take less than that, particularly if we're briefing issues beforehand. So, I don't know, 2 hours for argument total.
All right, thank you, Ms. Visser. Turning back to the states, you've heard from the defense.
Again, Judge, the state would prefer to argue tomorrow. We think the court has all the evidence before it and could make a bind over decision after oral argument tomorrow. If the court decides that briefing is necessary, I believe the court reporter could have a transcript available as early as Monday of next week at an expedited, on an expedited request. With that said, each side would need, 2 weeks to, we're the moving party. We would prepare a motion in support of bindover. There would be a response and then a reply. So we're probably 6 weeks out before we can actually argue before bindover. We would rather not wait 6 weeks to argue bindover. That's why we would like to do it tomorrow. But that's the timeline we're probably looking at, is about 6 weeks and then 2 to 3 hours of argument.
So are you requesting to move forward with oral argument tomorrow and in addition to briefing? Or again,
No.
I'm just trying to see the whole universe that's before me.
Good question, Judge. If the court wants briefing, I don't believe we would argue tomorrow. We would save that argument until the briefing is finished.
All right. Thank you. And to defense, would you agree on the time frame for briefing as been proposed by Mr. Grunander to allow each side the appropriate time, taking into consideration a transcript which may or may not be needed by the parties?
We are also okay with simultaneous briefing on this if the state prefers that. That wouldn't take 6 weeks if that's the concern, but we have no objection to the 6 weeks.
All right. And does your client waive any speedy trial rights that may result as this request? I just want to make sure I'm addressing constitutional rights. Also going to be addressing from the victim representative. This goes squarely into the victim's rights to speedy disposition. So again, I'm just trying to take it, and I know we're late. I just want to cover all these bases.
Yes, our client will waive his right, his speedy trial rights, so that we can properly brief the preliminary hearing issues.
All right. To the state.
If the court wants briefing, we would not like to do simultaneous briefing. We would like to start it out as the moving party. The defense would then respond. We would then have the opportunity to reply before oral argument.
All right. And I'll invite Ms. Kirk's attorney, if you wish to be heard. This goes squarely into the victim's rights as recognized in the Utah Constitution as well as the Utah statute as it's what's before us.
Your Honor, obviously we want swift justice for Charlie here. I think we obviously know the court needs to make sure they're balancing all interests here, but I think as soon as the matter could be bound over and this matter could be set for trial, that's what the Kirk family would like.
But do you want to weigh in regards to briefing? Because it sounds like it's...
Your Honor, I'm hesitant to weigh in on briefing. I feel as if that is a decision which the court should decide whether or not it's necessary. And we're going to take no position on briefing. We asked for speed. This has been 10 months coming. We've heard a lot of evidence. To me, it seems rather overwhelming, but that's my opinion. Obviously, it doesn't matter. So we just asked for it to move quickly.
Thank you. All right. Right, having heard from the parties, I will go ahead and allow, I'm granting the request for briefing as it relates to probable cause to allow both parties to file the briefs. With defense, as you are the moving party requesting briefing, when would you like to submit your brief? Or to the state?
Judge, because we have the burden, I believe it's appropriate for us to initiate the briefing
Okay.
because we're moving for the bindover, and then we would have an opportunity to reply.
And that's, okay, so let's start. Mr. Grunander, when can you have your brief filed?
Just a moment, Judge.
Thank you. And in going to defense, well, I'll follow up with you as well.
Thank you.
One moment, Mr. Grenander, I'm trying to get logistics so we can move this along. Mr. Grenander, turning to you.
Judge, if we were able to collect the transcript Monday, if we had 2 weeks from Tuesday, we could have our motion in, I believe that's the 28th of July.
All right, so state's briefed by the 28th of July, assuming that they can get the transcript by Monday. All right, state's brief, okay? Ms. Visser.
We need 2 weeks after that, so August 11th, I believe, is 2 weeks.
All right, and to the state, if you wish to file a reply, when,
It would be 7 days after that, Judge.
so
So the 18th?
August 18th. All right, and for oral argument, what I can set is September 1st in the morning. Let me take a quick glance here at the calendar. I'm trying to keep that close in time so we can move this along for all reasons previously stated. And we can start at 10 a.m. 10 a.m. on September 1st. How does that look for the parties?
That works for the state.
Your Honor, I'm going to be in trial that week, and I'd really like to be here for this argument. Is there any way we could just do it the next week?
Well, the problem is, I'm happy to look, but it is getting it would be very tricky. This is a fortunate opening.
Got it. All right.
Otherwise,
We'll take it then.
Okay. I appreciate you accommodating the court schedule. September 1st, in person? I see the defense nodding yes.
Yes.
Yes,
State?
please.
All right. September 1st at 10 a.m. And it sounds like up to 2 hours per side, and then can take it from there. Mr. Grenander.
Judge, page limits. We spoke as a team, and our preference would be to limit at least the initial briefs on both sides to 30 pages, no longer than 30.
Defense stipulates to that?
I'd like to counter with 40.
Okay, well, this is not an auction, but any final thoughts?
We'll submit it, Judge. And then we would ask for half of whatever Your Honor grants for the final reply.
We will set it at 35 pages, and then we will go half of that, which is an odd number, 17. We'll go 17 pages for the reply. Parties agree?
I was going to offer to round up to 18, but
I
that's
know.
fine.
We'll take the 18, Judge.
All right, we will go with 18. So 35 pages for the initial filings, 18 response, and September 1st at 10 a.m. Anything further for this evening?
Yes, Judge, I believe the Kirk family, there's a ruling that was reserved by the court with respect to publication of an exhibit that probably needs to be addressed.
Yes, and now my understanding is what's being requested is the portion that had been altered, which I believe is about 1 minute.
Your Honor, I believe it was enhanced, in that it was like zooming in and circles that were put on it. We would ask for the entirety of that exhibit to be displayed in court, so I believe it was about 8 minutes, if I'm not mistaken. Don't hold me on the
All
time.
right. Any final input on that? Thank you for reminding me from defense. Any final inputs? All right. What we can do is at the conclusion of defense's presentation of whatever witnesses they're going to do, we can address that. So the concern I heard was that the victim representative wanted to see what the court would consider before bindover decision is made, and that allots for that. So whether it happens right now, which the hour is late, or by right after the conclusion of evidence, that's going to help well before I consider bindover. So in the interest of justice and balancing that, I don't want to take away time. It sounds like we're going to be okay, but I always want to be cautious. but I will grant that request, and that will be played in open court, and we will watch the totality of, I believe it is State's Exhibit 12.1, which is 8, give or take, 2 minutes.
Your Honor, and just to clarify, it will not be televised, correct? It's only for people in the courtroom.
That is correct. Because the request was made by the victim representative who is present in court,
Right.
I will grant that request, and it will be played in the courtroom for all present to see, but not to be broadcast on TV.
And we just would like a continuing objection for all the reasons we raised before, Your Honor.
Thank you. I appreciate you making that record. I note the standing objection. That objection as it relates to this request is overruled, and that will be played at the conclusion of defense's presentation of evidence and before the state, if they do have a rebuttal witness. Please remind me so that I can address it, and that is taken care of. Thank you to the parties. I'm hesitant to ask this anything further. All right.
Nothing
see
further
no-
from the state.
All right, thank you all. I appreciate your hard work today, and that concludes court. We are in recess till 9 o'clock tomorrow morning.
All right.